today we have the UN Special Rapporteur on Minority Issues with us, Fernand de Varenne. Heartily welcome. And what we would like to hear is your reflection upon one very common dilemma or challenge when we speak of minority rights. People often say, or there are critics saying, well, what about the individuals within those groups, like women and children, if there are practices that really go against their rights or even their well-being within that little religious or ethnic or linguistic community?
From the point of view of international human rights law, minority rights are the human rights of minorities, and they're in fact individualistic rights. Of course, there are situations where you have a community which may have interests, pressures, practices, which may not always be consistent with international individual human rights standards. But that can be applied to majority or minority communities. So I just want to emphasize that there may be practices even in a country that is connected to the culture or the religion of the majority, where we can ask, does this really comply with human rights standards? So what you refer to, I think we have to think in a more general way. You may have, for example, in Christianity, practices that exclude women. In some Christian religions, women are not allowed, for example, to become members of clergy. Isn't that discriminatory? Well, a lot of people would say, no, not necessarily. It could be reasonable or not. So you have to consider that these are issues that are not limited or restricted in any way to minorities. This is a more broader matter that has to be considered. There are also in countries which have a Western background, for example, that do not allow abortions, which one could argue is a restriction on a woman's individual choice. For cultural or religious reasons. That also happens in majoritarian societies. So in all of those situations, my answer would be clearly, individual human rights have to be respected, especially the free will, the free choice of individuals. And if there are restrictions on their liberty, if you will, or their choices, then we have to look whether this is discriminatory or whether it breaches other individual human rights standards.
What about situations where there is a really small group, limited in number, where really the survival of the group is at stake because they have been limited of various reasons, of war, conflicts, refuge, etc., and where they have a long-standing practice that they only marry or have children with other members of their group? That, of course, raises specific issues, I assume, if one, for instance, consider the situation of women within these groups.
Once again, I would actually unpack that, because this can also happen with other religious groups that are not very small. You have certain religious groups who actually firmly believe that you can only marry within your own group. So it's not an issue that is limited to small minority communities. I want to discount that a little bit, because actually that's not accurate in many situations. But whether you have an extremely small minority or a larger religious group that is involved, the issue turns around, do people actually have the right to marriage, to make their own choice in terms of marriage in a voluntary way? And that is where you can have an individual human rights standard applying. If individuals, let's say young women, are forced against their will to marry within their group, or to freely marry anyone they want, the person they want, then you have a human rights issue. And it doesn't matter if it's a minority or majority. This applies individually to every kind of society and group.
What if a woman chooses, or not chooses, but somehow conceives a child with somebody from outside the group? Can the woman claim to remain a member of a certain group, like a religious group or an ethnic group, if the group does not accept her child because the child has a father who is not a member of the group?
Well, once again, if you only look at the narrow, what you just presented in a very narrow way, international human rights cannot force a religious group to accept someone as a member of their community. I think that would be, in a general sense, inappropriate. So if we limit ourselves to the way you've just described this, I do not see how you can force religious community to accept members who don't maybe share their values. That would be extremely intrusive, and I'm not aware that you can use international human rights in that way. And I think we have to reflect more on the complications that arises. There are complexities in that kind of situation. And in a general sense, once again, I don't think international human rights law can intervene in that situation, because we also recognize freedom of religion. There are limits, there are restrictions in international human rights law, but do they go to the extent that we could force a religious community to accept others or others as part of the community? I am not quite sure we could go that far.
And what about the cases where Indigenous women, for instance, have experienced that they are not allowed to remain on the property of the Indigenous group when they marry outside the group? There was a case in Canada, I think.
Yes, actually, that's the Lovelace versus Canada case, which I'm quite familiar with. I think we have to be a bit careful there. That was a situation where you had Canadian legislation that prevented women who had married outside of the Indigenous community from living on what was called then a reserve, the community, the territory of the community. But that, and the main conclusion was, in fact, that this was discriminatory, but also prevented Mrs. Lovelace from using her own language, enjoying her own culture with other members of her group. Now, the aspect that we have to keep in mind is that legislation was subsequently changed. She was able to live on the territory of the community, but this, by the way, was a decision, a conclusion of the United Nations Human Rights Committee. But this did not go as far as saying that the community, the Indigenous community, had to accept her as a member of the community, which is slightly different. So there were, yes, we could use individual human rights here, the right to use your own language and to enjoy your own culture with other members of your group. This was used in a way to allow her to live inside the community itself, but it didn't go so far as to require that she necessarily be accepted by other members of the community. Because if you think about it, how would you enforce that? If someone doesn't want to speak to her or interact with her, are you going to impose a fine? Are you going to jail that person? So I think there are complexities that can be involved, but in this case, and actually it was quite narrowly only on the issue of whether physically she can live within the same area.